early 1970s, tribal leaders, elders, aunties, grandmothers, and others testified at congressional hearings to share stories of their children being taken from them without cause. After extensive fact-finding, Congress concluded that state and private agencies were removing children from their homes and communities at a higher rate than non-Indian children, and many placed in non-Indian homes. They found the root cause was cultural biases and ignorance of Indian culture and social standards. The U.S. government had a unique political relationship with tribes who have been sovereign since the beginning of this country. The United States has a direct interest as a trustee and responsible for establishing protections for Indian children from the actions of state and private agencies. In 1978, the Indian Child Welfare Act, also known as ICWA, was enacted as a federal procedural and minimum standard of care applicable to all state agencies and courts involving an Indian child. In 1979, the Bureau of Indian Affairs published federal guidelines to provide consistency among states to comply with ICWA in child custody proceedings. In 2014, the Bureau of Indian Affairs held a series of consultations with tribal nations, and research found ICWA compliance by states was inconsistent, misinterpreted, and a disproportionate rate of 25 to 30% of Indian children continued to be removed. By 2015, ICWA federal guidelines were codified as a final rule in the Code of Federal Regulations on June 14, 2016. The intent was to develop a binding, uniform federal standard, best practices, and provide clarity to reduce litigation that left Indian children in limbo. The rule was to result in quicker outcomes and better results for Indian children. The guidelines included provisions requiring state laws which established protections beyond the minimal standard to be applied to child welfare proceedings. In state court proceedings, the Indian Child Welfare Act establishes the minimum procedure and substantive standards that must be met, regardless of state laws. The regulations provide a binding, consistent, nationwide interpretation of ICWA's minimum standards. ICWA displaces state laws and procedures that are less protective. Many states have their own laws applying to child welfare proceedings involving Indian children that establish protections beyond the minimum federal standards. In these instances, the more protective state laws apply. Some states and tribes have entered into negotiated tribal-state agreements that establish specific procedures to follow in Indian child custody proceedings. The agreements address the care and custody of Indian children and jurisdiction over child custody proceedings in state courts. Through the cooperative agreements, specific procedures are required for the protection for Indian children, which may include notification, financial arrangements regarding care of their children, and appropriate ICWA placement. ICWA straightens the tribe's sovereignty and autonomy in the administration of their own child welfare programs. The U.S. Department of Interior does not provide oversight on how, when, and if the tribe intervenes or participates in ICWA case proceedings. To ensure tribes have every opportunity to participate in child custody proceedings, the courts are to permit alternative means of participating, such as phone or video. This provision recognizes that tribal reservation or headquarters may be located far from the family's location or state court proceedings. In addition, the court is to allow tribal representatives to present before the court regardless of whether they are attorney or licensed in the state proceedings. The intent of tribes' access exercises their sovereignty, and providing information ensures consideration of the tribe's social and cultural standards in court decisions.